Okay, so let's take a look at an important case on occupiers' liability. This is the Glasgow Corporation versus Taylor 1922 case. And this is one of the classic cases that shows how the law protects children when they're on someone else's land, especially when something dangerous looks tempting. So here's what happened. A 7-year-old boy was playing in a public park owned by Glasgow Corporation. And while he was there, he came across some bright red berries growing on a bush. Now, to a child, they looked harmless, even a bit like sweets. But those berries were actually poisonous. Now, the corporation knew the berries were dangerous, but they hadn't put up a fence or removed the bush. Sadly, the little boy ate the berries and died, and his parents sued the corporation for negligence. So what is the legal issue? Well, the question for the court was this: was the occupier, so in this case Glasgow Corporation, legally responsible for the child's death, even though the child shouldn't have eaten the berries? And the House of Lords said yes, the corporation was liable. So here's the reasoning. The court said the berries were what's called an allurement, something that naturally attracts children. The corporation knew about the danger, and they also knew that children were likely to play in that area. Because they didn't take reasonable steps to stop harm, like fencing off the bush, they'd breached their duty of care. The judges also recognised that a young child wouldn't understand the risk, so the responsibility lay with the occupier and not the child. So what's the principle? Well, the key legal rule from this case is that occupiers must take extra care to protect children from dangers that might attract them, even if those dangers wouldn't affect an adult. And this idea is known as the allurement principle. As the court put it, where the occupier knows that something upon his land is a temptation to children, he must take steps to protect them. Here's some linked cases. You can compare it with Phipps and Rochester Corporation, where the occupier wasn't liable because the court said very young children should be supervised by their parents. And the rule from Glasgow v Taylor helped shape Section 2(3)(a) of the Occupiers Liability Act 1957, which says occupiers must be prepared for children to be less careful than adults. And if you need a way to remember it, well, alluring berries, deadly danger, the park must be aware of the curious child.